thank you very much for that kind introduction. And perhaps if I didn't have this speech this morning, I may have been tempted to a karaoke bar last night. But I had to focus on the mission ahead here. I will say one other thing, interestingly, which flows out of the conversation yesterday, which is, although I grew up in Toowoomba, Queensland, I was in fact born in Lismore, not far from Casino in the Northern Rivers. So it seems that there is a tradition of members of this society originating just south of the Tweed River and promptly moving north. At the outset, I should say, as the inaugural Dr. Nancy Stone Fellow for the Society, I'm very grateful for the support that that fellowship has afforded me, particularly in terms of pursuing the BCL at Oxford. I think it was in 2010 that Dyson Hayden mentioned, when discussing John and Nancy Stone's contribution in life, that Nancy was in fact the lifeblood of the Samuel Griffith Society, and I hope that in my own way I can honour that legacy in contributing to the Society today and into the future. So today we'll be talking about NZYQ and the proper bounds of judicial power. Australia's constitutional compact is the product of considerable deliberation and principled consensus informed by a rich legal, political and cultural history. The respective roles, powers and responsibilities of the central institutional components within this compact, the legislative, executive and judicial branches of government, must, I contend, be exercised within their proper bounds in order for the Commonwealth to function effectively. Recent jurisprudence regarding the judicial power of the Commonwealth under Chapter 3 of the Constitution has stretched the bounds of this power through inelegant judicial reasoning, which risks impeding the proper exercise of the legislative, executive and judicial powers of the Commonwealth. In particular, the decisions of the High Court in the recent cases of NZYQ and the Minister for Immigration, Citizenship and Multicultural Affairs, ASF 17 and the Minister, and YBFZ and the Minister, are indicative of the development of an expeditionary jurisprudence which I say must be arrested and corrected. In this paper, I advance three claims regarding the nature of judicial power, its exercise in the Australian constitutional context, and the risks the trajectory of recent jurisprudence in this respect presents. First, that the underlying premise regarding a strict separation of exclusive judicial power is somewhat ahistorical and ought not be left uncontested. That is to say, the foundational premise upon which recent expeditionary jurisprudence from NZYQ to YBFZ proceeds is not as sound as might appear at first blush. Secondly, I contend that the inelegant ambiguity deployed in the reasoning of the majority in NZYQ and its progeny has enabled and resulted in an improper expansion of judicial power into a roving jurisdiction through which the judiciary may craft a judicial Bill of Rights by stealth. Finally, the development of the so-called principle of legality in the United Kingdom in recent decades stands as a salutary warning of the risks which such expeditionary jurisprudence and inelegant ambiguity present in terms of improper arrogation of power to the judiciary if left unchecked. To make good these claims, this paper proceeds in three parts. At the outset, Part A canvasses the historical background to the judicial power of the Commonwealth in Chapter 3 of the Constitution. Part B then proceeds to consider the parameters of judicial power in the context of the jurisprudence of NZYQ through to YBFZ, arguing that the law has taken a wrong turn and improperly sought to expand the bounds of the judicial power of the Commonwealth in so doing. Finally, Part C will draw on the jurisprudence surrounding the principle of legality in the United Kingdom to demonstrate likely trajectories this expansionist Chapter 3 jurisprudence in the Australian context. And so we turn to Chapter 3 in context. while it is beyond the scope of this paper to exhaustively interrogate the abstract or institutional separation of powers required by the Constitution, it is necessary briefly to canvass the historical background which informs the reasoning upon which much of the contemporary Chapter 3 jurisprudence is based. At the outset, it is trite to observe that the Convention debates and contributions to those debates made by figures who loom large over the formation of the Commonwealth of Australia, such as Barton, Inglis Clark, and the namesake of this organisation, Sir Samuel Griffith, reflect the legal and historical depth of the principles which undergird the constitutional architecture of this nation. It is true that the establishment of three great arms of state, including a jealous defence of establishing a federal judicature, as elements of the nascent Australian Federation, was addressed during the 1891 Convention, lest the Commonwealth of Australia be tainted by an imperfect constitution and thwarted by a mutilated government. However, while these statements, read in conjunction with the structure of the Constitution itself, may at first blush lend credence to the conclusion that a separation of powers doctrine along the lines propounded by Montesquieu was in the framers' minds, I note Sir Robert Garran's reflection on the division of the first three chapters of the Constitution into legislative, executive, and judicature as a draftsman's neat arrangement without any hint of further significance. Further, Sir Samuel Griffith himself appeared to cast doubt on the wisdom of Montesquieu's strict separation of powers doctrine during the debate of resolutions at the 1891 Convention. I should say, on the topic of those individuals who seek to read things into the Constitution that they wish were there, which arose in yesterday morning's session, I simply observe that it was Justice Isaacs in the Wheat case who penned the seminal judgment on a strict separation of powers required by the structure and content of the Constitution. That is the very same person who, as Mr. Isaac Isaacs, had been defeated on the floor of the Constitutional Conventions on this very point, but I digress. In his analysis of the separation of powers within the Australian Constitution, whether abstract or institutional, John Finnis considered there to be nothing in the Convention debates that could be taken as a commendation of the abstract doctrine of the separation of powers, and otherwise concluded that no abstract doctrine of separation of powers could have been deduced from the structure and drafting of the 1891 Constitution. Geoffrey Sawyer, in his commentary on the judiciary and Australian federalism, went so far as to state that there is no evidence that the Federal Fathers in general had the slightest desire to imitate the French theory of separation of powers, which was based upon a misrepresentation of English practice, nor the American theory, which was based on a misrepresentation of the French. Suffice to say, there is substantial historical support for the conclusion that a strong separation of powers was not necessarily the intent of our constitutional framers, even with respect to the separation of judicial power in the abstract. However, despite these strong historical indicia which tend against the conclusion that a strict separation of powers was intended by the framers of the Australian Constitution, several significant subsequent cases, including most notably the Wheat case and Boilermakers, firmly established as a matter of constitutional jurisprudence that a strict separation was required and intended. Relevantly, in the Wheat case, Justice Isaacs articulated the first limb of the separation of judicial power doctrine, holding that the Commonwealth judicial power could be vested only in Chapter 3 courts, whilst the majority in Boilermakers established the reciprocal second limb that only Commonwealth judicial power or powers incidental to that power could be conferred upon Chapter 3 courts. In light of these decisions, Finnis observed that even those who regret it accept that the founders of the Australian Constitution beyond question intended the separation of powers now required by the Boilermakers case. Relevantly for the purposes of this paper, the legal view embedded by Boilermakers was taken up by Justices Brennan, Dean and Dawson in Chu Keng Lim and the Minister for Immigration, Local Government and Ethnic Affairs, where the court considered the exclusively judicial character of the adjudgment and punishment of guilt in the context of immigration detention, and that reasoning has further flowed through to the decisions of the High Court in NZYQ and YBFZ. The foregoing demonstrate that there is, in fact, a very real tension between the historical, legal, and political origins of the separation of powers, and the judicial power of the Commonwealth in particular, on the one hand, and the development of legal precedent on Commonwealth judicial power in Chapter 3 of the Constitution on the other. It is this very tension which finds expression in the recent jurisprudence in NZYQ and especially YBFZ, for the reasons which follow. It is a tension which I contend cannot and will not be resolved until a future majority of the High Court display firm fidelity to the historical context in which the Constitution was settled. Turning to NZYQ and the bounds of judicial power then. The misconception of history and the conflation of legal precedent with historical fact, which risks improperly expanding the bounds of Commonwealth judicial power, has manifested in the recent jurisprudence of the High Court in the two recent decisions of NZYQ and YBFZ. Considering these decisions in turn, I'll demonstrate that a certain jurisprudential inelegance in the majority's reasoning in NZYQ regrettably sowed the seeds for ahistorical jurisprudential conclusions in YBFZ that are, with great respect, entirely divorced from both the historical context of the Constitution's creation and the historical exercise of judicial power. Before assessing those decisions, it is necessary to briefly consider the parameters of the judicial power of the Commonwealth itself. As Justice McHugh observed in Lim, by reference to two separate decisions of Chief Justice Griffith and Justice Kitto, an exhaustive definition of judicial power has proved elusive. In Haddad Parker and Co. and Moorhead, Chief Justice Griffiths opined that the words judicial power as used in Chapter 3 of the Constitution mean the power which every sovereign authority must, of necessity, have to decide controversies between its subjects or between itself and its subjects, whether the rights relate to life, liberty, or property. Justice Kitto later proffered a further formulation of judicial power in the Tasmanian Breweries case, stating that judicial power involves a process which must generally be an inquiry concerning the law as it is and the facts as they are, followed by an application of the law as determined to the facts as determined, and the end to be reached must be an act which, so long as it stands, entitles and obliges the persons to whom it intervenes to observance of the rights and obligations that the application of law to facts has shown to exist, and that a power which does not involve such a process and lead to such an end needs to possess some special compelling feature if its justification in the category of judicial power is to be justified. Suffice to say, having considered these two descriptions of judicial power, I am in firm agreement with Justice McHugh's conclusion that they illustrate the imprecision attaching to lines between judicial power, executive power, and legislative power, and that the line between judicial power and executive power in particular is very blurred. Consequently, as Justice Windier observed in Tasmanian Breweries, consideration of judicial power inevitably attracts consideration of predominant characteristics and also invites comparison with the historic functions and processes of courts of law. With these considerations in mind, the recent decisions in NZYQ and YBFZ and the jurisprudential approaches taken by the court in those cases can be assessed. In NZYQ, the plaintiff was a stateless Rohingya Muslim who was born in Myanmar sometime between 1995 and 1997, subsequently arrived in Australia by boat in 2012, and was consequently taken into immigration detention on arrival pursuant to Section 189 of the Migration Act. After being granted a bridging visa and released from immigration detention in 2014, he was convicted of a sexual offence against a child and sentenced to a period of imprisonment. Following his release from criminal custody in 2018, he was again taken into immigration detention, under Section 189(1) of the Migration Act. During the time he was incarcerated, NZYQ had applied for a protection visa, and a delegate of the minister found that he had a well-founded fear of persecution in Myanmar, but due to his criminal conviction, he was not granted a protection visa. Consequently, he remained in continuing immigration detention pursuant to Sections 189(1) and 196(1) of the Migration Act. The plaintiff challenged the authorisation of his detention under those sections and claimed in the alternative that those provisions contravened Chapter 3 of the Constitution. In Al-Kateb and Godwin, the High Court by majority, being Justices McHugh, Hayne, Callanan and Hayden, held that sections 189(1) and 196(1) of the Migration Act, operation properly construed, authorised the continuing detention of a person in NZYQ's position, and that, so applied, those provisions did not contravene Chapter 3 of the Constitution. The decision in Al-Kateb presented an implacable barrier to the plaintiff's claim, unless the court was satisfied that it was appropriate to reopen and consider the holdings in Al-Kateb. The court was ultimately satisfied in NZYQ that the applicable considerations weighed against reopening the statutory construction finding in Al-Kateb, but weighed in favour of the constitutional holding being reopened. Accordingly, the court considered the question of whether the constitutional holding in Al-Kateb should be overruled by reference to consistency of that holding with the Lim principle. That principle, that is the Lim principle, expressed at an appropriate level of generality, is that a law enacted by the Commonwealth Parliament which authorises the detention of a person, other than through the exercise by a court of the judicial power of the Commonwealth in the performance of the function of adjudging and punishing criminal guilt, will contravene Chapter 3 of the Constitution unless the law is reasonably capable of being seen to be necessary for a legitimate and non-punitive purpose. In other words, detention is penal or punitive unless justified as otherwise. In Al-Kateb, Justice McHugh had considered that a law requiring that detention of the alien takes its character from the purpose of the detention. As long as the purpose of the detention is to make the alien available for deportation or to prevent the alien from entering Australia or the Australian community, the detention is non-punitive. The court in NZYQ, however, unanimously held that His Honour's foregoing articulation was an incomplete and accordingly inaccurate statement of the applicable principle. In so doing, the court emphasised the point that the executive detention in this context must be limited to a period that is reasonably capable of being seen as necessary for a legitimate and non-punitive purpose, namely the removal of an alien from Australia or enabling an application by the alien for permission to remain in Australia to be made and considered. Critically, the court held that where there is no real prospect of removal from Australia becoming practicable in the reasonably foreseeable future, the inference that must be drawn is that the purpose of the detention is punitive, and in turn would constitute a breach of Chapter 3 of the Constitution. As the court put it pithily, in such circumstances the detention would merely be for the purposes of detention. Now, the fundamental difficulty with the court's approach in NZYQ overturning the decision in Al-Kateb is twofold. First, it demonstrates a certain inelegant jurisprudence insofar as the rationale relies on particularly broad, sweeping statements which, in my respectful contention, go beyond what was required in the circumstances to determine the case. For example, at paragraph 40, the court refers to and relies on broad concepts of constitutional discourse and compatibility with constitutionally prescribed systems of government to assess whether an impugned legislative objective is legitimate and non-punitive. Further, at paragraph 28, the court refers to the statement of principle in Lim that involuntary detention in custody by the state is penal or punitive, but then goes on to hold that this statement of principle reflects Chapter 3's concern with substance and not form, and in particular, the involuntary deprivation of liberty as ordinarily constituting punishment. Notice the judicial glissade here, as the reasoning moves from a statement of principle about detention to one focused more broadly on deprivation of liberty. It is here that the rumblings of the coming storm in YBFZ are most clearly heard. Secondly, the approach of Justice Edelman proceeds upon the premise that the concept of punishment in Lim deploys the concept in two different senses. At paragraph 53, His Honour articulates these as consequences imposed based on classic criminal notions of just desert and a novel conception of punishment which treats a law as punitive because it employs means that are disproportionate to its legitimate purpose. For completeness, I know that Justice Edelman's reasons in ASF 17, which swiftly followed NZYQ and concerned an Iranian national who refused to cooperate with his removal to Iran, further advanced and built upon this conception of punishment and proportionality to a legitimate purpose. Taken together, these two prongs of the ratio in NZYQ nudge open the door for a more radical expansion of the bounds of judicial power of the Commonwealth, as they arm the bench with tools of sufficient flexibility to fashion the scope of such power in its own image. Which brings us to the second recent decision that demonstrates the consequences of such an approach, that of YBFZ. The decision in NZYQ resulted in the release of a substantial number of individuals from immigration detention. The plaintiff in YBFZ was a stateless Eritrean who had been convicted of serious offences, sentenced to a period of imprisonment, and was subsequently held in immigration detention pursuant to sections 189(1) and 196(1) of the Migration Act, but was released and granted a bridging visa as a member of the so-called NZYQ cohort shortly thereafter. The bridging visa that was granted to YBFZ formed part of the Commonwealth legislative response to the court's decision in NZYQ and included, inter alia, conditions requiring the wearing of a monitoring device and compliance with a curfew. The plaintiff challenged the constitutional validity of the migration regulations, which impose the monitoring and curfew conditions, on the basis that they contravened Chapter 3 of the Constitution. The plurality, Chief Justice Gageler and Justices Gordon, Gleeson and Jago, held that the impugned migration regulations were invalid because they contravened Chapter 3 of the Constitution. Justice Edelman also held them to be invalid for separate reasons. In so doing, their honours relied on the court's previous decision in NZYQ, which, in their view, represented, and I quote, a broader stream of common law and constitutional principle based on the preeminent value the law in this country gives to the protection of life from arbitrary capital punishment, limb, now called bodily integrity, from arbitrary corporal punishment, and liberty from arbitrary detention. Justices Stewart and Beach-Jones both penned persuasive dissents and gave separate reasons in support of their respective positions. Broadly speaking, I embrace the reasons given in Justice Stewart's dissent. His Honour, quite rightly, at paragraph 187, observed the consideration of the characteristics of judicial power must be anchored in our legal heritage, either as historical fact or as a permitted analogy to that legacy, and otherwise reiterated, paragraph 175, the orthodox understanding of the limb principle being addressed towards state-enforced detention as falling within the exclusively judicial function of adjudging and punishing criminal guilt. At paragraph 176, Justice Stewart further highlighted the concerning trend within recent jurisprudence of the High Court to extend the limb principle to strike down laws passed validly by Parliament concerning matters which have not ever, historically or otherwise, been the exclusive preserve of the courts, citing the decisions of Alexander and the Minister for Home Affairs and Benbrika and the Minister for Home Affairs as relevant examples. His Honour's principled approach to ascertaining the bounds of Commonwealth judicial power and, I argue, proper recourse to a historical context and legal heritage to inform the determination of issues relating to Chapter 3 of the Constitution is to be welcomed. However, in light of the inelegant judicial glissade identified in NZYQ, I must respectfully disagree with His Honour's conclusion that the decision in that case was, in truth, confined to issues of the limb principle as applied to detention of an alien for the purpose of removal or deportation from Australia. On the contrary, several segments within the plurality's reasons in YBFZ draw on the well of the reasoning in NZYQ to support an expansive and possibly entirely novel conception of the bounds of Commonwealth judicial power in Chapter 3 of the Constitution. At paragraph 14, the plurality described the move from detention to the deprivation of life, bodily integrity and liberty as the evolution of the common law's repeated rejection of arbitrary punishment of the individual and its expression in the doctrine of the separation of powers, which is of fundamental importance. Their Honours further opined that the doctrine of the separation of powers and the common law rules protecting a person's liberty and bodily integrity spring from those same underlying values. On this basis, the plurality shifted the focus from detention to the detriment imposed on an individual's liberty, as was presaged in NZYQ. In the instant case, this led the plurality to conclude that the imposition of a curfew condition involved a deprivation of liberty of a material and relatively long-term nature. Similarly, the plurality considered that the detriments imposed by the wearing of a monitoring device also had a material and relatively long-term effect on the wearer. Their Honours even went so far as to suggest that the monitoring condition, that is, the wearing of an ankle bracelet in this case, effects an involuntary restraint on the liberty of the wearer and, giving this specific example, might further encroach on the personal liberty of the individual by impacting the types of clothing that individual might wear. Now, it strikes me that Blackstone and A.V. Dicey, and indeed the constitutional framers, would be stunned to learn that the determination of what constitutes exclusively judicial power or the adjudging and punishment of criminal guilt might extend to the attire of aliens. These expansive conceptions of the bounds of Commonwealth judicial power are, I contend, the direct progeny of the expeditionary jurisprudential method outlined in NZYQ, and are emblematic of the consequences of failing to properly appreciate the historical facts which inform the nature and scope of judicial power. At paragraph 183 of YBF said, Justice Stewart considered that the expansion of the limb principle in this manner has the potential to enable the introduction of a judge-made Bill of Rights, which will incrementally deny the executive branch its power. I go further and contend that the expeditionary jurisprudential approach of the plurality in YBF said not only diminishes the sovereignty of the executive branch of our constitutional compact, but that it also dispossesses Parliament of its own authority and consequently diminishes our democracy. The risks that such an approach presents are readily discernible from jurisprudential developments in the United Kingdom. The risks presented by what Justice Stewart had described in YBF said as reasoning from highly generalised, undefined and abstract concepts, or perhaps aspirations, are readily apparent in the development of the so-called principle of legality in the United Kingdom. It is particularly instructive in circumstances where parliamentary sovereignty is absolutely central to the fabric of the British Constitution, and the judiciary in the United Kingdom have, in my respectful contention, plainly sought to expand the bounds of judicial power in that jurisdiction. The classic formulation of the principle of legality in the contemporary law of the United Kingdom is captured in two decisions of the House of Lords in the late 20th century. Those are the decision of ex parte Pearson and ex parte Sims. In Pearson, both Lord Brown-Wilkinson and Lord Stein canvassed the nature and parameters of the principle of legality. Lord Brown-Wilkinson held that a power conferred by Parliament in general terms is not to be taken to authorise the doing of acts by the donee of the power which adversely affect the legal rights of the citizen or the basic principles on which the law of the United Kingdom is based, unless the statute conferring the power makes it clear that such was the intention of the Parliament. Lord Stein adopted the phrase principle of legality to broaden the principle to encompass his contention that Parliament does not legislate in a vacuum. Parliament legislates for a European liberal democracy founded on the principles and traditions of the common law. Both their lordships' decisions proceeded on the basis that Parliament is presumed not to intend to change the common law or abrogate constitutional rights, absent a clear indication to the contrary, either through express language or necessary implication. In Sims, Lord Hoffman reinforced the decision in Pearson, stating that fundamental rights cannot be overridden by general or ambiguous words, and in the absence of express language or necessary implication to the contrary, the courts therefore presumed that even the most general words were intended to be subject to the basic rights of the individual. For his part, Lord Stein reiterated his earlier position in Pearson and went further, describing the principle of legality as a presumption of general application operating as a constitutional principle. This principle of legality is derived from these authorities, and the historical antecedents may be described as a constitutional principle which acts as a defensive device directed towards securing fundamental common law constitutional norms. To adopt Lord Stein's phrasing, it is a presumption of general application which ensures that Parliament may not interfere with or abrogate basic common law constitutional norms, absent express words or necessary implication, and in so doing, the principle of legality operates as a constitutional principle. In some respects, this may seem like orthodox reasoning, but I suggest that in both of these decisions we can hear echoes of the appeals to the ethereal and abstract constitutional concepts relied upon in NZYQ and YBFZ. Analogously, the foundational contemporary public law cases of Pearson and Sims plainly conceive of the principle of legality as tied to the task of statutory interpretation and inextricably linked to the existence of legislation which may be assessed for its clear expression or necessary implication when purporting to displace the presumption of Parliament that Parliament does not intend to abrogate the common law. So far, this is entirely orthodox. However, noting that this nexus between the principle of legality and legislation is also borne out in the ensuing cases where the principle of legality has been invoked, the arc of jurisprudence on this principle has not been immune to the impact of judicial activism. The risk of an erroneous freestanding constitutional principle of legality is highlighted by decisions of the UK Supreme Court in Evans and Attorney General and Privacy International and the Investigative Powers Tribunal. Drawing on something of a synthesis of the principle of legality as articulated in the decisions of Lords Brown-Wilkinson, Stein and Hoffman in Pearson and Sims, Lord Neuberger in Evans sought to expand the principle of legality beyond its previously established boundaries. His lordship in that case relied on the statement of Baroness Hale in Jackson and the Attorney General that the courts will, of course, decline to hold that Parliament has interfered with fundamental rights unless it has made its intentions crystal clear, to justify not merely looking to whether Parliament had drafted express words that displaced the presumption not to abrogate fundamental common law constitutional norms, but to enable deeper judicial intervention into the meaning of the language used by Parliament. Similarly, Lord Carnwath in Privacy International suggested that nothing less than the clearest wording would suffice to displace the presumption against abrogating fundamental common law constitutional norms, in that case, the supervisory role of the courts. These decisions are troubling insofar as they appear to sow the seeds for a principle of legality divorced from its foundational purpose and historical context. And moreover, they reveal the risks of decoupling important legal principles from the historical and legal antecedents. While the principle of legality remains somewhat contested in the United Kingdom, the development of its jurisprudence plainly indicates the risks of improper expansion of the bounds of judicial power when highly generalised, abstract and aspirational concepts are relied on as the foundation for the development of legal doctrine. In both the United Kingdom and in the Australian context, such approaches risk diminishing the strength and vigour of the executive, and critically, the Parliament within our Westminster system of government. In conclusion, the bounds of the judicial power of the Commonwealth contained in Chapter 3 of the Constitution cannot be properly determined in isolation. Importantly, the historical context of Australia's constitutional origins and the historical exercise of judicial powers are not merely instructive, but essential to the development of sound jurisprudence on the nature and extent of Commonwealth judicial power. There remains an unresolved tension between the historical context of Chapter 3 of the Constitution's creation and subsequent legal authority interpreting its import and effect. Recent jurisprudence on this issue, with great respect, has proceeded on what I describe as a misconception of these historical considerations and improperly conflated legal precedent with historical fact in both NZYQ and YBFZ. As outlined in the foregoing discussion, I respectfully contend that the decision in YBFZ is divorced from history, both in terms of powers historically exercised by courts and from the historical origins of Chapter 3 of the Constitution itself, with the plurality in that case preferring an ahistorical approach that relies on highly undefined and abstract concepts. The expansion of the bounds of Commonwealth judicial power in NZYQ and YBFZ has created a crack which members of the judiciary may pry open with the crowbar of a roving jurisdiction that enables them to arrogate to themselves the right to improperly veto Parliament's decisions and the actions of the executive in accordance with individual judges' conceptions of certain underlying constitutional common law rights. Noting that the decision in YBFZ was effectively a decision of the plurality of the court, I remain optimistic that the force and content of Justice Seward's dissent in particular may be drawn upon by a future majority of the High Court to arrest and correct this wayward jurisprudence. Thank you for your attention.